Hola a todos, muy buenos días. Damos la bienvenida a la charla Introducción a los principios del licenciamiento socialmente responsable, experiencia de la Universidad de Michigan. Por favor, solicitamos verificar que estén consignados en su usuario de Zoom sus nombres y la institución a la cual pertenecen para poder tener una adecuada identificación durante la actividad. Asimismo, se informa que esta actividad va a contar con una traducción simultánea y para ello deben acceder al icono inferior del costado derecho de su pantalla. A continuación, van a dar las palabras de bienvenida a esta actividad doña Romina Cataldo, que pertenece a la Comisión de Reconocimiento y Cultura de la Innovación de la Red Quech, y don Luis Villarroel, que es director de la Corporación Innovarte. Bienvenida, Romina, tienes la palabra.
Muchas gracias, Maribel. Buenos días a todos y todas en esta mañana de día jueves. Nosotros estamos de acá de Temuco y en particular nos es muy grato esta iniciativa porque parte oficialmente el trabajo conjunto con Innovarte y este grupo, o digamos como subconjunto de personas de la red de innovación del CUECH, quien tomó este desafío de posicionar la temática de licenciamiento socialmente responsable, que el año pasado, 2025, hemos estado haciendo un trabajo. Innovarte hizo un diagnóstico, hizo un levantamiento de todas las universidades estatales y nos dimos cuenta que es una temática que todos relevamos y consideramos importante, pero que sabemos poco y tenemos poco eh, manejo de los conceptos y que quizás sí estamos implementando, pero cómo lo potenciamos, cómo lo podemos divulgar y cómo podemos hacer más consciente esta temática, dado nuestra naturaleza de universidades estatales en nuestro territorio y en nuestro país. Así que muy agradecidos de Luis. Thank you very much, Bryce. Welcome to this meeting. We are very grateful for your presence and your knowledge in this area. So we will be very happy to hear you in this morning in Chile. Así que sin ninguna otra palabra, doy el paso a Luis, quien está trabajando con nosotros y es el director de Innovar.
Muchas gracias, Romina. También para nosotros este taller con el cual formalmente damos inicio al plan de trabajo que esperamos que conducirá a consensuar principios de licenciamiento socialmente responsable que las universidades estatales chilenas consideren que son pertinentes, atendida el mandato legal en cuanto a su misión de contribuir a sus territorios y al bienestar social. Además, esperamos que en este trabajo que comenzamos construyamos recursos que permitan, faciliten la implementación de estos principios que llegaremos a discutir y consensuar. Ahora, en este proceso hay distintas etapas. Estamos comenzando la etapa de conocer las experiencias extranjeras de universidades líderes de innovación, quienes ya han iniciado la implementación de principios que, como vamos a ver durante estas charlas, van variando dependiendo de los países en que se encuentran. Y luego tendremos una fase en la cual compartiremos experiencias a nivel nacional. Ahora, este es un proceso que es inédito en Latinoamérica y esperamos que pueda servir como un modelo que pueda ser implementado en otros países, pero también consideramos que es muy importante la experiencia que ya tienen universidades latinoamericanas y estamos muy honrados que hoy día participen también como observadores de representantes de la Universidad Cayetano Heredia de Lima de Perú y de la SPOL de Ecuador, a quienes les mandamos un cariñoso saludo. También se va a incorporar un representante de la CEPAL y de Georgetown University, en calidad de observadores para que vayamos construyendo una comunidad internacional que nos contribuya. Sin más, quiero darle la palabra a Bryce Peels. Bryce Peels tiene un currículum impresionante. Voy a leer solamente algunos elementos para que ustedes, quienes no lo conozcan, dimensionen su experiencia. Bryce Peels es vicepresidente, asistente de investigación y licencias y alianza estratégica de la Universidad de Michigan. La Universidad de Michigan, como bien nos lo va a explicar Bryce, es la universidad pública de investigación más grande y completa de Estados Unidos. Así que su experiencia es muy valiosa y sin más dejo la palabra a Bryce. A continuación de la presentación de Bryce, tendremos un espacio de conversación, así que vayan preparando las preguntas, las observaciones, aprovechemos que podemos dialogar con Bryce sobre las dudas que tengamos sobre este mecanismo. Pueden ir haciendo las preguntas por escrito, eso nos permite un poco ir dimensionando los intereses que haya, pero una vez que entremos a las preguntas, y conversación lo haremos también oralmente. Muchas gracias, Bryce. De nuevo, tú eres un tremendo líder y muy generoso con tu tiempo, así que tienes la palabra.
Well, hello, everyone, and thank you to Luis and Innovarte for inviting me to talk to all of you. It's a pleasure to talk about something that's very important to us at the University of Michigan, which is socially responsible licensing. Please feel free to ask questions at any point or to reach out after this discussion. I'm happy to talk more about how we do this at the University of Michigan. And I'm sure there's things I can learn from all of you as well. So a little bit about the University of Michigan. We are a large public research university in the state of Michigan in the northern United States. Last fiscal year, we did over $2 billion of research, and that funded over 1,600 individual research projects. We have a large medical school, a large engineering school, and a lot of social sciences. So we see inventions from all disciplines. And last year, that led to over 670 new inventions that were reported to our team at Innovation Partnerships. And that led to the creation of 31 new startup companies to try to bring these early stage innovations to the public to address major issues in the world. In the last 20 years, we've had over 40 biomedical products approved for the treatment of patients, and those products originated from university laboratories. And so we've had a lot of experience in structuring partnerships in a way to maximize positive societal impact. And that is our goal at Innovation Partnerships. We often talk about our mission being to make sure that every discovery that comes from a Michigan laboratory has its best opportunity to change the world. We focus on maximizing positive societal impact. And that shows up most frequently in thinking about our approaches to working with our innovators, our approaches to structuring partnerships, and that's something that we refer to as socially responsible licensing. So this is something that US universities have been talking about for a long time. In fact, in 2007, a group of universities got together and they said, this is a very difficult thing we're trying to do, and we're all trying to do it in the public interest. Let's agree upon a set of principles that can be flexible. These are things that we should keep in mind and consider as we do this work of working with innovations coming from our laboratories to help us make sure that we're maximizing positive societal impact. And you can see here this set of 9 principles that was established in 2007. It's been adopted by over 120 research universities, including a few in Latin America. It's been the basis of other principles that have been adopted, for example, in Netherlands. And while a lot has changed since 2007, these have stood up well to the test of time, and there's something that we try to follow at the University of Michigan. And so what I'm hoping to do today is go through each of these 9 principles and talk about how we try to implement that principle, struggles that we see and that we deal with here, and how we figured out how to handle those struggles. And then at the end, I'll give you a bonus principle that we have adopted at the University of Michigan that we try to follow. So the first principle relates to reserving research rights, that even when we exclusively license an invention, we want to reserve the right to still use that invention in research and to be able to partner with other nonprofits to use that invention for research. And the first point I'll make is that this is necessary. There is not a fair use principle for patents, at least in the United States. And so if you exclusively license the patent rights to a partner, you don't have the ability to still use that invention in your own laboratory research. You can't say, well, I was only using it for non-commercial purposes. I was only using it for research. If you've exclusively granted the rights away, you don't have the right to do that unless you have specifically carved out those rights in the license. And so that is something that we are very careful to do, is to make sure that we can still continue the research in our laboratory to try to improve that invention, to try to find other uses of that invention. Now, this provision is heavily negotiated in our exclusive licenses. When we have decided to license an invention to a for-profit company, and especially when we've decided to do it exclusively, it's because they are going to invest millions of dollars and years of work in this. And, they are very aware of, who else could be using this invention and could it impair their innovation efforts in any way. So one of the things our licensees will often try to change in this provision is they'll try to say that you can't use the invention in partnership with another for-profit company. It's what we call industry-sponsored research. And that's something we try to protect and we try to still have the ability to do. But that is something that we can be flexible on if the inventor agrees to that. And so what we'll do is we'll talk to the inventor and we'll say, hey, what they're saying is that you wouldn't be able to work with another company, doing research in your laboratory. And if the inventor is comfortable with that, that is something we will agree to. We still have the right to do federally funded research, and we still have the right to do nonprofit partnering research. Another thing licensees will push back on is the ability to use the invention in clinical research. And this is something that we understand, at least in the United States, when a company is taking a biomedical product through clinical trials, the Federal Drug Administration is very aware of any sort of negative results regarding that biomedical invention. And so if the university were to initiate its own clinical trial or partner with someone else on a clinical trial and it generated some bad data, that could shut down all clinical trials. And so, we think it's fair that if the inventor is comfortable with that we will say we won't do any clinical research. We'll still do laboratory research. We can still use the IP for research, but we won't test it in humans. And then the last request is often where the licensee will say, if you're going to partner with another nonprofit, can you let us know? You're still allowed to do it, but they just want to know that, hey, we're partnering with another US university, a Chilean university to do this. So they have an understanding of all the places where research is going on. And that is something we will agree to. We think it's fair, as long as we're still allowed to use the licensed intellectual property in research. So the second principle, which is a big one, is diligence, is that when you license intellectual property to a for-profit, they need to work really hard to bring that to the market, because that is our mission. That's why we are doing this, is to maximize positive societal impact. And we don't want a company to license our invention solely to keep it away from their competitors. And so in order to prevent that, besides trying to choose really good partners, we will put diligence milestones into our license. And this is a standard position of ours. It's something we insist upon. And so you can see here to the left are standard diligence milestone provisions. And that first provision at the top, 5.1, is what we would call general diligence. It just says the licensee needs to use diligent efforts to bring this to market. That is good, but it's not perfect, because if we felt they weren't being diligent and they felt they were, that would be a difficult thing to argue about as to, whether they were being diligent or not. What's more important is provision 5.2, which is what we call specific diligence. And here's where we say, you will do the following 5 things. And here they're blank, A, B, C, D, E. But for each licensee, we would choose what are the 4 to 8 things that we feel that any licensee would need to do if they were responsibly trying to bring this innovation to the market. This is something that also gets heavily negotiated, because a licensee is going to understandably say, hey, this is unpredictable. We're a startup company. This is early stage science. We have no idea how this is going to go. And so it's a discussion. And what we will often do is we will take the slide deck that they give us, which is them, touting why they're a good licensee and why they're the best partner. And we'll say, here's the 5 to 8 things you said you can do. Let's talk about the dates by when you'll do these. And sometimes we'll even say, here's the diligence milestones you have to meet. You choose the dates, you fill those in. We just need to have some objective dates. Something a licensee will often try to do is they'll try to modify this by saying they just need to use commercially reasonable efforts to meet those dates. And that is something that we will not agree to, because we don't want to be arguing over what's commercially reasonable. This needs to be an objective standard. You either will meet that by the date or you won't. And if you don't, then we'll have a discussion about whether we want to modify the agreement to keep working with you, or whether in the best interest of the technology, we need to find a new partner. This is an area where it's very important to be precise with your language. Quite often when we're doing a license, we're working from a template agreement. And so quite often, there's very little free drafting that our licensing team is doing. But this is one area where quite often, they are typing in the words here. And if these diligence milestones are ever being discussed years down the road, the actual words are really going to matter, where the licensee is, trying to say, oh, we did raise enough funding to bring this to market, because we got this government grant, and we want to be able to say, well, a government grant doesn't count. And so you need to be very precise about what funding will meet that milestone, what it means to develop a prototype, what it means to have a first, product that reaches the public. The precision will matter. But this is a very important provision for us. A lot of our products that have reached the market have done so through a second or a third licensee, where the first partner we chose wasn't able to sufficiently bring the product to market. They missed a diligence milestone, and so we were able to get the IP returned to us and find a new partner that was able to maximize positive societal impact. Another important thing to consider is what happens when they miss a milestone. So unless you specifically say that the IP gets returned to you and the license terminates, it won't terminate. You'll just, you'll be able to sue them for damages. But that is not what any of us are after, right? We're not looking for a cause of action to get some money from the licensee. We want them to perform and get the product to the market. And so it's very important to be precise about, if they miss a milestone, here's what happens. And normally what we say happens is they tell us they missed a milestone. We tell them that you've got, some period of time to cure that, to make the milestone. And if they don't, the license terminates. Here's where we will build in some flexibility. So for example, sometimes we'll agree that the licensee can, on one occasion, extend the milestone by paying an extension fee. And again, that's the extension fee is not for us to make money. It's just to show that they are serious about still developing this invention. So there are some ways to build in some reasonable flexibility there, understanding that things outside the licensee's control can happen. And you can always agree on your own to extend the milestones. And we do that frequently, where it's still the best partner. We understand that the clinical trial is going to start later than expected. And so we will voluntarily agree to extend the milestone because they're still the best partner. Another principle is to be aware of licensing future improvements. So quite often the licensee says, we really like this invention and we're going to try to bring that to market, but we really like this laboratory and the research they're doing. And so we want to make sure we have rights to their next invention. And that is something we generally will not do. For each invention from a laboratory, we want to be able to choose the best partner to try to bring that to market to maximize positive societal impact. And so our general principle is that we will only license an invention that we know about. We won't license future inventions. Now, there is a very narrow definition of improvements that we will agree to sometimes, because sometimes the licensee says, hey, if it's this invention, but you improve it in the next 2 years, like we'd like to have access to that and know you're not going to license that to our competitors. And so this specific definition of an improvement is something that we will agree to. And you can see here that it's very narrow. It only covers an improvement in the next 3 years. It only covers an improvement that would necessarily infringe the patent that's already been licensed. And it has to be invented by the same inventors that were included on the original invention. So that allows the inventors to consent to this and say, yes, it's okay. We understand if we improve this invention, we will tell this licensee about it and we'll give them the option to add to the license. So it's a reasonable compromise while still protecting different future inventions that come from that laboratory. The fourth principle is managing conflicts of interest. This is something that comes up often at any university. And in fact, something we say here is if we're partnering and if we're entrepreneurial, there should be a lot of conflicts of interest. You want your faculty to be launching startup companies and partnering with people outside the university. What's important is to manage those conflicts of interest in order to protect the integrity of that researcher's research and the integrity of the university's research. You want them to know that we are doing research that aligns with the public interest, not to further a faculty member's financial interests. And so in every license we do, there's a provision that requires the licensees to cooperate with us in managing conflicts of interest. Our general management principles are that a person that has a conflict of interest, and so where they have a role or they have a financial interest in the company outside the university, they need to disclose that in any papers and any presentations. They need to tell the students in their lab that they have this interest. We will appoint what we call an ombuds person, which is a neutral faculty member that the students can go to if they have concerns. So for example, if a grad student feels like their supervisor is making them do certain research just to help the company, but not to further the science, that could be an uncomfortable thing to bring up to their supervisor. And so they can go to this neutral faculty member and say they have these concerns. We will allow researchers to continue using IP in their research, even when it's been licensed. That's something that some universities will not allow. So for example, if you launch a startup company and you license IP to it, the lab needs to change its research so it's not continuing to research that licensed technology. We will allow that because we feel that's in the best interest of science. You want to have the best minds in the world, the best scientists still working to further that, even if it helps the company, but we're not doing it to help the company, we're helping to advance science to increase the likelihood that that product reaches the market. And then because we're a public university, there's a law in our state that requires any license we do with a conflicted entity, which is almost all of our startup companies, to be approved by our regents. And so there will be some overarching oversight over these deals. But we figured out how to do it in an efficient way so that we're still able to partner while still protecting the integrity of our research. The fifth principle, and it's a big one, is to ensure broad access to research tools. But we adopt this for all technologies, not just research tools. Because again, our mission is to maximize positive societal impact. And so that happens most easily when as many people as possible can access our intellectual property and can access the products that result from that intellectual property. Because the technologies that come to us are amazingly different. One can be a survey, another can be a potential therapeutic, another can be a robot. there's needs to be different models for these different technologies. And so we have a variety of different models, and I'll talk about those a bit. The first is that whenever possible, we try to non-exclusively license. That aligns with our mission to allow as many people as possible to work with these scientific discoveries to bring them to market. That's the preferred model. So last fiscal year, we did 283 licenses. 240 of those were non-exclusive. The only times we'll do an exclusive license is when it's very clear that there's going to be so much investment needed to bring the science to market that that partner needs to have exclusivity, that they are not going to invest the millions of dollars and years in clinical trials if there's competitors. And so we try to be very careful to understand that that is needed in order to do an exclusive license. Otherwise, we'll try to do non-exclusive licensing. Before this, we forwarded an article that talks about our licensing model for the cystic fibrosis gene patent, which was invented at the University of Michigan in the 90s. This is a very famous invention because one of the inventors was Francis Collins, who went on to head the National Institutes of Health here in the United States. And so a very prolific, big name in science. And when he came up with this invention, there was a lot of thought here at the University of Michigan about what is the licensing model that's in the best interest of society and the public. And we worked closely with the inventor. We worked closely with experts at Toronto Hospital for Sick Children and the Cystic Fibrosis Foundation to figure out the right licensing model. And we non-exclusively licensed that. We had different licenses for different uses. And so we did charge fees. The University of Michigan, received money in return for this that was used to fund additional research. And that was important. But we were still able to do that in a way that maximized the number of people that were able to use this test. And so the fees were much lower for people that were generating diagnostic tests to be used in a laboratory, in a hospital. The fees were a little bit higher for someone that was building a kit that then they were then selling. And we were very careful about people that were developing therapeutics from this. There was one exclusive license granted to a company that was trying to develop a therapeutic, but that was for only one of the patents that was very specific to a particular vector. So this was something that was done, many years ago, decades ago, but the people that were involved in it were very thoughtful about a licensing strategy that would maximize positive societal impact. And they did it in a way where there was still revenue that came into the university that was used to fund additional science. And the article I forwarded was an article from researchers that were very positive about this approach, saying that they interviewed lots of people in the field and that these patents and the licensing strategy from the university did not get in the way of anyone's innovation. And so we think that's a good model. One thing I'll point out is when they developed this licensing strategy, they worked closely with a NGO, a non-governmental organization called One World Health, that had expertise in how this diagnostic could be used in low and middle income countries. And that is something that we try to do, is we try to partner with humanitarian organizations because we don't have expertise on international matters and how to bring technologies to low middle income countries. And so there are humanitarian organizations that do have that expertise. And so we will frequently consult with them to learn what is the best licensing model to maximize positive societal impact. We do a lot of end user license agreements. And so these are agreements for software or content where we can non-exclusively license it. And we make these available through our website, where someone that wants to access a piece of software, of content, a patient-reported outcome can go right to our website, click agree, and get access to it. We have a lot of what we call patient-reported outcomes, which are questionnaires, surveys, often developed from years and millions of dollars of research. And so while they may seem simple, often they're just a 10-page Word document with a set of questions. There's tremendous expertise and thought that have gone into these. And we make these freely available to academics and nonprofits through our website. We like to talk about there's over 1.5 million patients that have been given a voice through a University of Michigan patient-reported outcome, and we have over 30 patient-reported outcomes that are actively being made available through our website. Just because you make something freely available to other scientists doesn't mean you can't also license that under a commercial model. And so we do a lot of what we call dual track licensing. And this is very common for digital research tools. And so a piece of software that helps someone with biomedical research, we can make that freely available to someone that works at a nonprofit or a university, while we can have a commercial model for someone at a for-profit. And this is a very common model we use, where we will offer a 60-day free trial to someone at a commercial entity, and then they need to pay to extend that license. And so we have several inventions where there's been thousands of academic licenses granted for free, no charge, and dozens, sometimes hundreds of paid commercial users, which allows us to make this broadly available, yet still have a return that funds additional research. One question that often comes up for university inventions is fields of use. University inventions are often applicable to multiple different uses, and sometimes you can't even anticipate them at the early days of seeing the invention. And so wherever possible, we will try to preserve the right to find other partners for other fields of use. But often the licensee would like to have as many fields of use as possible. And sometimes that's understandable because they want to raise money, they want to find their own partners. And so rather than trying to limit them to just one field of use, one approach we will use is that we will grant them an exclusive license in all fields of use. But then we have a provision like this one, where we say, if there's a field of use for which you're not developing the invention, and an interested third party approaches us and we think they'd be a good partner, we can then do one of four things. We will let you know, and then you either need to show us that you are trying to pursue that field of use. You can sub-license to that other party. You can amend the license to narrow your field of use so we could license to that third party. Or you could say that you are going to commit to that field of use, in which case we'll amend your license to have specific diligence milestones. So this has been a flexible model that's worked well for us, that allows us to fully partner with initial licensee, yet preserve the flexibility that if someone else approaches us to pursue another field of use, that we still have the ability to partner with them. The last thing I'll mention about our licensing models is we do a lot of work with open source licensing. And so at the University of Michigan, we will let our faculty decide if they want to release an invention through an open source model, and we will fully support them in doing that. And so we provide a lot of education, a lot of training around selecting the right open source license and facilitating that model, because it's an extremely effective model for making an invention broadly available to anyone that wants to use it and partner with it. And again, you can do dual track licensing. You can make something open source for certain uses or to nonprofits and academics, while preserving the ability to license it on a commercial basis to for-profits. The sixth principle is enforcement. And so the notion of this principle is that universities should be very careful if they ever are using litigation to enforce a patent right, and you need to be careful about allowing a licensee to enforce. And so when we grant an exclusive license, it's important for the exclusive licensee to have the ability to enforce the patent, that if there is someone who is recklessly infringing their rights, they want to have that right, but we want to put controls on it. And so the controls that we place are, first, the licensee needs to have sufficiently advanced the innovation to market. There needs to be a product on the market or clinical trials before they could ever even think about using our patent rights to sue someone else. They have to do a thorough investigation to make sure they have a good faith basis. They have to let us know so that we have a chance to talk to them and understand why they're doing this and whether this is in the best interest of the product. And we're trying to strike a balance here to make sure that a licensee isn't using litigation or using enforcement in a way that would impair innovation. The seventh principle is to be careful about export regulations. And for this, I'll talk about know-how. And so know-how refers to non-public data or information or concepts. That's different than the patent rights or the copyrights we could be licensing. And in the last few years, there's been a lot of attention given to know-how. That when we are partnering with someone, they'll say, we don't just want to license your patent rights, we want to license your know-how. And I think there's a few reasons for this. One is they're just very aware that they want to make sure that they have freedom to operate under any intellectual property the university has. There's also tremendous value in this know-how, especially in a data-driven world with AI. They want as much data, as much information as possible. And there's some forms of know-how that can't be patented that have a lot of value, such as drug targets. At least in United States patent law, you can't get a patent on a drug target. You can only get a patent on the mechanism of attacking that target. Yet there can be tremendous value in a target. One of our scientists may have found a new target as a potential treatment for leukemia that no one else knows about. And so people will want to be able to license the know-how around that information. It's very important to us to protect academic freedom and preserve our ability to research and for the ability for our scientists to go out and talk about this. And so we will never exclusively license know-how. And you can see here a definition of know-how that we'll use and the non-exclusive grant clause we'll use for know-how. And sometimes this may be in a license where we're granting exclusive rights to a patent, but we will nonetheless ensure that the know-how is only non-exclusive because that is information. And that's something that we want our faculty to be able to publish, to be able to talk about, to be able to partner with other companies and share that information. And it shouldn't be locked up with just one company. The other thing we'll be careful to do is make sure that there's no future requirement to deliver know-how, that we will say, hey, the know-how that we will non-exclusively license to you is only the know-how that you have right now. You can't come to us in a year or two and force our faculty member to give you more information. That's up to them and how they disseminate that. The eighth point, back 20 years ago, they talked about patent aggregators, but really this is just partner selection and making sure that you choose qualified partners that are motivated to bring your science to market to benefit society. And we will spend significant resources in qualifying the people we're working with, because not everyone that approaches us for a license is an appropriate licensee of a public funded innovation. So one of the things we will often do is before we enter into a license, we will first enter into an option agreement, which allows the licensee to do due diligence and assess the invention. It allows us to learn more about them and decide whether they are a qualified licensee to partner with. And this is the language in our option agreement where we say, if at the end of your option period, you want to go ahead with a license, this is the information you need to give to us. And we have the ability to decide whether you have a competent team, whether you have the resources needed to bring this to market. We understand it's still risky. We understand that most innovations fail and don't reach the public, but we want to make sure that you are the best partner possible to try to overcome those odds and bring this to market. The most important criteria for us is the relationship between the inventor and the licensee. So again, we work very closely with our inventors, even though they may not be the experts, but this is their innovation. Often, they're the ones that are most motivated to make sure that their innovation makes an impact in the world. And so we want to make sure that they are comfortable with this licensee and that the licensee is comfortable with the inventor, because that relationship is going to be ongoing throughout the year. They're going to need to come back, for consulting and get information from that inventor, and the inventor needs to be comfortable that this company is the right one to bring this forward. So the ninth point is that in exclusive licenses, universities should be thoughtful about putting in terms to ensure that unmet needs in the world are addressed. And this is one that addresses the inefficiency in the marketplace. That even if we choose a really good partner, even if we put milestones in place And even if they get a drug to market or a biomedical product to the market, they may just get it in one market, right? And, they may be able to get sufficient economic return from making that available in the United States and Europe, but not be motivated to expand access worldwide. And so we've put a lot of thought into what provisions we should use in our license to try to overcome that market inefficiency and allow affordable access to biomedical innovations that reach one market. And historically, there's been 3 different models for this. One is to reserve the right for the university to try to use that invention for public service or to meet unmet needs in the world. The other model is compulsory sublicensing, where the university can make the licensee partner with other people. And the third model, which is more of a modern approach, is called affordable access plans. And this is something that was pioneered by our friends at the University of California in Los Angeles and Medicine's Patent Pool. But we have adopted this third approach, and we have seen a lot of success with it in recent years. And so it's tiny print, but this is the affordable access plan language that we use in all of our pharmaceutical licenses. And how it works is that it says that once there's a drug that is approved, then the pharmaceutical company needs to give us information. That information is about what are the low and middle income countries that it is not planning to pursue. And then for other low middle income countries, what is it doing to make the drug affordably accessible in those countries? And then they need to agree to talk to us. And so the benefits of this approach is it's not prescriptive, it's not requiring them to do anything. It's information sharing, and it initiates a conversation. And maybe that information's enough because quite often they don't have patents in those low middle income countries. And so us knowing that they're not interested in those countries allows us to go ahead and partner with humanitarian organizations to bring the drug to market in those countries. And then it also allows us to partner, to create partnerships between the pharmaceutical company and those humanitarian organizations. So we have a memorandum of understanding with Medicine's Patent Pool, which is a great humanitarian organization that partners with us and other universities to help in these conversations. And we know there's other humanitarian organizations that could also step in and help. The other reason this has worked well is that this is something that a lot of pharmaceutical companies are already doing. 77% of large pharmaceutical companies already have their own access plan. And so we're not requiring them to generate information they don't already have. We're just requiring them to share it with us where the invention was created and to have conversations. The other important thing is that this applies to the drug, the product, and not just the patent. One of the shortcomings of compulsory licensing or the reserved right is that it only covers the university patents. But quite often, during the 10 to 20 years of development of that drug by the licensee, they will file their own patents on the formulation or the method of use. And so the university being able to compel them to license the university patent has no effect. It's not enough because the pharma company has their own patents. But with the affordable access plan, we're talking about the drug itself and where it can be made available. So in our last 12 exclusive therapeutics licenses, we've gotten this provision into the license without any negotiation or any changes. This is accepted by law firms, it's accepted by venture capitalists. These startups have gone on to raise 8 funding rounds of over $1 million. And so one of the things you often hear from licensees is, if you put that provision in my license, I won't be able to raise money or I won't be able to partner. And that is not true. This provision works in a license and allows them to go out and raise money. So it's something we're very excited about. We're eager to get the first drug approved that has this provision in and to see how it works with the information sharing and the partnering. The last principle I want to share, this was not in the autumn principles, but this is something that is near and dear to our hearts at the University of Michigan, is to focus on the impact of investment and not the return of investment. And so that even if a project comes to us and there's no chance of it ever generating licensing revenue for the university, we will still fully support it. And we have seen a lot of this with innovations coming from our social sciences schools. Innovations where the right way for it to get out of the university is through a nonprofit. There's a lot of interest in doing this. And so our office has worked to develop the resources to support these inventions. We know how to support an invention that's going to go to a startup that's going to try to raise venture capital and get to a big market. But we also have developed the resources to support something that's going to go into a nonprofit. And those resources are often expertise around whether they should spin out or whether they should stay at the university. A lot of these projects are existing centers at the university where they're kind of already doing it. They're already offering training materials or consulting services. But they realize that if they spin out from the university, they may be able to expand their impact and address more of the world. And so we help them with that decision. We've developed expertise to help with entity selection. Should they be a nonprofit? Should they be a B Corp? Should they be a for-profit but socially minded? And a big set of these resources is fiscal sponsors. So when a nonprofit leaves the university, it's often extremely expensive and time consuming to get the nonprofit tax exempt approvals. And so the right thing to do is to first license the invention to an existing nonprofit that can serve as the fiscal sponsor. And then when the nonprofit project gets to the point where they can get approved for tax exempt charitable purposes, they can spin out from there. And so that is something we're actually in the process of creating. And so this is a model that's in the works here, where we are going to create what we call a social impact accelerator, which is a nonprofit entity that sits outside the university, but can fundraise for these nonprofit projects. We will grant an IP license for the intellectual property that's been created in the University of Michigan laboratory to this nonprofit. And this can serve as the fiscal sponsor, where that project incubates, can fundraise, can develop traction and hire people. And then when it's ready to create its own 501c3 nonprofit, it can spin out from the university. We have done this through other fiscal sponsors, over the last few years, but we're excited about creating this as a vehicle to spin out more of these nonprofits. And we went through and we have a list of 30 projects that we think are ready to be their own nonprofit and spin out through this vehicle. And again, we're able to do this because when an innovation comes to us, we're not thinking, what is the ROI? We are thinking, what is the impact this can make in the world and how can we help it? So with that, thank you for your time. Thank you for listening to me. Again, I am happy to answer any questions either now or later. Please feel free to reach out to me either through email or LinkedIn. I'm happy to continue the conversation. But this is extremely important work for us to be engaged in. There's a lot of problems in the world, and I'm convinced that the solutions to these problems are in our universities, and it's our job to make sure they get out into the world and can reach the public to improve the conditions in the world.
Muchas gracias, Bryce. En realidad tu presentación es muy informativa e inspiradora. Nos permite comprobar que es posible hacer compromisos a nivel de las universidades para maximizar el impacto social y con ello no se pierde la competitividad de las innovaciones, sino que por el contrario se enriquece con el valor social. Este es un trabajo que requiere la cooperación internacional, el diálogo, y para nosotros es, como ya lo dije, es un gran privilegio contar contigo en este trabajo. Y tenemos algunas preguntas de los asistentes. Bryce, tienes que saber que acá nos acompañan de las oficinas de transferencia tecnológica y de las direcciones de innovación de las 18 universidades estatales de Chile. También nos acompañan de Ecuador y de Perú. También tenemos con nosotros a Sharon Ann Lynch, que ella es directora de United y también directora de un programa de Georgetown University. Yo les pido a los compañeros de las universidades que que hagan las preguntas y comentarios que tengan. Es muy importante aprovechar que tenemos a Bryce y esto es una reunión entre amigos, así que por favor siéntanse muy libres para expresar. Tenemos ya un par de preguntas que es de Viviana Busto de la Universidad de los Lagos. Yo le pediría a Viviana que lo haga en persona para que nos veamos las caras y empecemos la conversación. Viviana,
Hello.
hello Viviana.
Can you hear me?
Yes.
Yes, I'm so sorry. Is something wrong with my video? My connection is a little bit unstable, and I'm sorry. Thank you very much for the lecture. It was brilliant. Thank you very much. I'm trying to turn on my camera, but it's not working. And my question is related to the agreement for licensing. Okay, I would like to know if, in your experience, what is the principal considerations and critical elements involved to develop a standard technology licensing agreement? Because we have some technologies that we can licensing, and we have some offers from some international companies, but we have been a little bit struggling with the agreement, because if you look at the reference of I don't know, concerns coming from the solicitors, you can get a huge amount of considerations. So, in your experience, which would be the main tips that we have to consider at the moment to develop a technology licensing agreement? Thank you very much. I'm so sorry about my camera.
No, no problem. Well, congratulations on having inventions where there's interest, from people outside the university. As many of you know, that's a rare thing. It's very hard, to take these early stage science experiments and try to find someone outside the university that's interested in investing time and money to bring them to market. And when you have someone approaching you, let alone multiple companies, it's a rare thing. I think the first thing we would consider is partner selection, which, if any of those entities are appropriate partners, and do they have the capabilities and the conviction to bring this to market? I think the next question would be, does this have to be an exclusive license, or could it be non-exclusive? And quite often you can get feedback from those partners. You can say, hey, like, we're planning to non-exclusively license this to multiple partners. How do you feel about that? And sometimes we've had partners that have said, don't do that. Like, that it has to just be one partner. And they're like, even if it's not us, that's fine. But none of us can invest the time and money in this if there's multiple people using it. And so it's often, you can get honest feedback from them, which is a good test that makes you realize, like, yeah, this is something where the exclusivity is going to matter, and maybe we can narrow the field of use, maybe we can split up that way, but we probably just need to choose one partner initially to try to bring this to market. And then next, it's going to be the diligence milestones, because that is the roadmap for how they're going to bring this to market, the certain gates they need to get through in order to keep the license. And that is a good and important part of the discussion, which is, what are they willing to commit to in terms of getting an impact from the invention? And then last would be the economics. Once you've crossed those hurdles, and for economics, we often say our guiding light is that if they create significant value from this, they should share some of it back with the university. And the ways to do that is through risk sharing, that quite often a royalty, or when they make money, there's some they share back. If it's a startup, some equity, perhaps some downstream milestones. But often there, it's like a conversation with the general notion that, hey, if you if you create value for yourself, there should be some shared back with the university because that's important for you to share with the inventors and to reinvest in research. And I'm happy to talk more specifically about various comps for that, but that would be our framework and our approach.
Okay, thank you very much because I was wondering, economic is usually the most important thing for the university, usually the people start from the economics, and I was very good the analysis that you made because it's the last one, it's the third point. Yeah.
Yeah, our view is like you do the right thing and the economics will follow. And the meaningful economics come from when there's a product that reaches the marketplace. And that
Oh,
requires a good partner who reaches their milestones. And if you don't have that, it's not going to matter. And so, it takes so long that like most of our meaningful economic return comes from licenses that we did 15, 20 years ago, where we chose the right partner, stuck with them, and now there's a product in the market that's helping the public, but also providing a meaningful return.
thank you very much. Thank you,
Eh,
Luis.
Muchas gracias, Bryce, muchas gracias, Viviana, por la pregunta. En orden cronológico, tenemos una pregunta de Geraldine Espinosa de la Universidad Peruana Cayetano Heredia. Eh, Geraldine, ¿la quieres hacer en vivo para que te conozcamos? Bueno, yo te conozco, pero que te conozcan.
Sí,
Saludos.
claro. Thanks all for the presentation. It was amazing. I think that always listening to this kind of experiences help us a lot to consider about different scenarios. For this particular case, I was reading the paper that they sent us through email, and the first thing that got my attention was how did you manage to protect something that we may classify as a discovery rather than an invention, and not only the SFTR but also the mutation? So you protect both. How was it possible? Is what was that something about the regulation of those years, perhaps?
Yeah, I think that's part of it. So this was the mid 1990s, and patent law has changed since then. And so it has definitely become much difficult, appropriately so, to patent genetic related inventions. And so it could be the case that some of the patent claims we received in the 1990s would not be ones that you could receive today. The other thing is that, while we talk about the cystic fibrosis gene as being the thing they patented, it wasn't. It was things that were created from the natural occurring sequence that were patented, like uses of it, vectors from it were where most of the patents were filed. So it wasn't the discovery itself that was patented. But I think both those things are true, is that the law has changed significantly. It would be much more difficult to get patents in that space. And then what is actually being patented is applications of the gene itself.
All right. And then something just to follow this question is, for example, we deal in the university with some researchers that when they get this kind of results, they go for or they aim for academic openness. So how do you deal? Is that common in Michigan, or I mean, does it cause any kind of trouble for the intellectual property team?
Yeah, it can. I mean, we try to frame the discussion in terms of impact, which is like, hey, that is what we're trying to do, is maximize positive societal impact. And number one is, we can pursue intellectual property protection and partners that can create a product or service, and you can still publish. So none of this is getting in the way of your ability to publish and your ability to share your results with everyone. But and we've actually had a few faculty members talk about this in a very eloquent way, which is, it's one thing to share your discoveries with other academics. It's another to translate that into an actual product or service that actually, saves lives and extends lives and improves lives, right? And so that's like a broader impact that you can have through patents and through partnering. And then we can talk about like why the patent is needed to partner and to develop that product or service. It's not stopping other people from using it. It's not stopping you from publishing. It's just creating a vehicle to get someone outside the university to invest the time and money to take your amazing science and turn it into a product that can be used to treat patients.
Okay,
Muchas gracias.
thank
Muchas
you.
gracias, Geraldine, por la pregunta, Bryce. Evelyn Enríquez de la UFRO. You have the floor.
Thank you. Hello, Bryce. Really, really nice to meet you. That was very interesting to hear. My question is, I'm just curious. You mentioned that you have a board of regents to manage your conflict of interest. And I was just wondering if you have any cases where this board didn't approve any startups, and why and how did you handle that?
Right. So it's a good question. So what we do here is that we have 2 conflict of interest committees that do all of like the heavy investigation into the startups. And so one handles it for anything medical related, the other committee handles it for anything that's non-medical. And that is where the close scrutiny occurs. And that is where they sometimes will not approve something. And then typically they don't say no, they'll say, hey, you need to put in these safeguards or these precautions. And typically it will relate to the kind of the research relationship with the company. So for example, if the company is partnering with the university on research, they need to make sure that the university faculty member is not working on both sides of that research partnership. They need to pick a side and be on that. There'll often be, safeguards around the students and disclosures and things like that. But that is where sometimes the startups will not be approved. Once they've passed through the committees, then the regents is generally approving those. And I can't remember the regents ever rejecting it. It's because they're relying upon all the hard work that's done at the committee level.
Perfect. Thank you. Thank you very much, Ruth.
Muchas gracias por la pregunta, Evelyn. Romina Cataldo, de la UFRO.
Hello, Bryce. Thank you for your talk. I realized you have a very flexible model based on a wide range of negotiations that are quite specific for the type of IP you are trying to license, okay? Do you have all these capabilities installed at the university, or you are supported by other legal offices that are specialized in the kind of IP you want to license? That is my first question. And the second one is, what is the level of participation of academics in decision-making process for licensing?
Good questions. So most of the time we do have the resources internally. So we are a relatively big office where we have 72 people in our office. We have 2 attorneys that are in the Office of General Counsel that sit with our team and support us. And we are always talking to our peers. So like we're always, we're going to meetings and learning from UCLA and Berkeley and Harvard and Stanford. And so one of the things I like about this field is there's a lot of information sharing between universities. And so, even if we haven't figured out a good model for something, quite often someone at another university has. And so I can pick up the phone and call my counterpart at Harvard and say, hey, how are you handling this situation? And we do work with outside law firms for patent protection, but mostly that's in, securing the patents. It's not so much in the licensing model. And the other thing is because there's such a high volume, we can be very experimental where, I feel like we can try new things, because there's just lots of deals we're doing. And we don't feel like we need to get each deal perfect its first time. We're obviously trying really hard, but we can try something new and see how it works. And therefore it's a good way to figure out that we have the right model based upon the technology. But as you know, things are always changing. We're seeing lots of inventions now that are AI based. And so it's like figuring out how you license those, whether you even try to patent them, what is the real value and who's the right partner. One of the fun things about the profession is that the science is always changing and forcing you to figure out new models. The second question was, remind me your second question.
Yeah, it's about what is the level of participation of academics in decision-making process?
Yeah, so we heavily involve our academics. So one of our principles is inventor-centered innovation, and that we very much view the innovators as our customer. And even though the university may technically own the IP, like it's really the innovator's IP, right? Like that is their baby that they've worked years to develop. And so we work very closely with them. We often say that we're not the experts, we're not the gatekeepers, we're not the police, we're the guides that are kind of helping them climb a mountain. And so we can point out various alternatives to them. We can talk about like the risks and the benefits, but we're very much kind of like walking them through the process. And there's a few checkpoints we make sure that we check with them. So they need to approve any licensee that we want to partner with. They need to approve, certain of the terms in the license. And when we kind of continue to work with that licensee, we're always checking with the inventor saying, how is it going? Do you still feel like they're the best partner? And I know not every university is like that, even in the United States. I know there's several universities that are a little bit more hands off the inventors, or like the inventor gives the invention and the university does what they want with it. But we feel our model works really well. It has led to a lot of innovations coming to our office for our inventors. They trust us. They know that we're going to work closely with them and try to achieve their goals. It also helps us be socially responsible, because it's normally the inventor that's looking to make impact. And, they want to make sure that their innovation treats everyone around the world, not just people in the United States. And so we have found that if we work closely with the innovator, it just helps us make good, appropriate decisions.
Muchas gracias, Romina. No veo otras preguntas del público, así que voy a aprovechar para hacer algunas desde la moderación o la provocación. Hay diferentes principios dependiendo de los países, por lo que hemos observado. Y en Europa vemos que el principio de participación de las comunidades y los pacientes, en el caso de tecnologías de salud, es algo que también debe ser considerado. La consulta para Bryce es si dentro del modelo que ustedes implementan consideran instancias en las cuales hagan consultas a los que van a ser afectados por la tecnología dentro del proceso de otorgar una licencia. So in English, in short, will be, if you integrate communities and patients in the case that you are processing a technology transfer of a given health technology. Do you integrate, or it's not a principle that you have within those that you apply?
I would say we generally try to get as much information as possible about the right thing to do for an invention. And, for example, like we will partner with humanitarian organizations, we will partner with, community organizations. We have large centers at the university that focus on global health equality and public policy initiatives. And we will partner with anyone we can to help them make appropriate decisions. One of the struggles is that quite often you're doing a license so early, like before you even know what the innovation will be or what will be the market or world dynamics when it reaches the market. For most of our biomedical innovations, when they get approved to treat patients, we did the license 15 or more years ago. And so you may have opportunities to amend the license and, structure the partnership based upon new information you're getting. But yeah, we're always, open to work with people to figure out what is the right model to maximize positive societal impact.
Okay. Gracias, Bryce. And another question is, which principles from those that you are implementing you think that are core principles? Because we are in the process of identifying what are the principles that should Chilean universities adopt. And we are looking different models. The U.S. model, Belgium, the Dutch, everything. So we are opening our eyes to the foreign experience. So if you were to choose, what are the most relevant principles that you think that should be exported? And also, if you think that there is a principle that is not listed within those that you have implemented, or if you have the possibility of creating a new principle and a new standard, what would that be?
That's a great question. So of the 9 principles, I think the 3 most important are around partner selection, being careful and providing a lot of thought in who you partner with. Don't just do a deal because you can do the deal or because there's some money there, but choose someone that truly is the best possible partner to bring that technology to market. The other is diligence milestones, is ensuring that there's provisions in the license that require the licensee to progress that technology to market. That is the single biggest pain point for us where we do a deal where we later regret it. It's where we did the license 5 years ago, and now the inventor no longer feels like that's the best partner. He or she is frustrated. They're taking too long. Maybe they think they're pursuing the wrong path. And we don't have a good diligence milestone in order to get the IP back. Either like we didn't draft it precisely enough, or we just didn't put something in at that point in time to require them to be bringing it to market. And like that is just a really important principle and a really important practice. And then the other would be reserving research rights. Because that is really what allows the university to continue doing great work and come up with the next great invention, is being able to still use that IP for research and to be able to partner with others. The principles that are not in that 9, one would be the one I mentioned, which is being able to focus on impact even when there's no possible revenue return to the university. And so that is, kind of developing and being able to support social impact projects, even when there's not, an ROI in terms of revenue. And then the other, which is one of our office principles, which I think would be a good core principle for everyone, would be what I would call inventor-centeredness, is, focus your office on providing amazing customer service to your researchers. And that should be the orientation of your office, because I feel like if you do that right, all sorts of other good things happen. And we often talk about that when we hire people, when we evaluate our staff, is, are you delivering amazing customer service to our faculty? Because if we do that, everything else falls into place. We get lots of inventions, we get lots of deals, we get products that reach the marketplace.
Muchas gracias. Last chance para hacer una consulta o comentario a Bryce. Si no, le doy la palabra a Isabel Arauz, coordinadora del Red de Innovación. Y hubo una omisión de mi parte al principio. Tengo que agradecerle particularmente a Isabel y a Anaí por el apoyo y confianza que han tenido en organizar este trabajo. Así que, sin más, dejo con ustedes muchas gracias, Bryce, a Isabel para dar las palabras de cierre.
Bueno, agradecer a Bryce. La verdad es que yo me sumé un poco tarde a la presentación, dado que estaba en otra reunión, pero este trabajo ha sido, yo creo, de manera sustancial para nosotros, avanzar hacia el licenciamiento socialmente responsable para las universidades estatales en Chile. Agradecer la colaboración de Luis y todo su equipo desde Innovarte por invitarnos también y abrir este espacio de diálogo para una temática que desde lo público, desde lo social, nos hace mucho sentido, ¿no? Como red de innovación. Agradecer a Romina y a toda la comisión detrás de este ejercicio que iniciamos a través de este ciclo con Bryce desde la Universidad de Michigan y que esperamos que pueda ir también avanzando hacia la exploración y el conocimiento también de otras experiencias internacionales que nos permitan ir consensuando y visualizando desde la práctica, ¿no? Desde el hacer, cómo podemos incorporar algunas orientaciones, principios que nos hagan sentido, bajo una lógica también de apropiación, de acuerdo al desarrollo de nuestras universidades, ¿no es cierto? Y que esto vaya desarrollándose en una línea también propositiva, que es un poco el espíritu del trabajo de esta red de innovación. Así que muchas gracias a quienes nos han acompañado, sobre todo a Bryce, porque sé que preparó esta presentación con tiempo. Estuvieron ustedes también en conversaciones previas para poder lograr este cometido, este ejercicio. Y por otro lado, agradecer también la información complementaria que nos hizo llegar de algunos artículos que creo que también nos viene bien poder tener otros insumos, ¿no? Y otros recursos más bien pedagógicos que nos faciliten un poco también la comprensión más allá de lo que él ha presentado desde la Universidad de Michigan. Así que a todos quienes han hecho posible este encuentro y esta jornada, muchas gracias y, sobre todo desde la red queremos como agradecer a quienes han hecho posible esta actividad. Así que muchas gracias, Luis, a ti y a todo tu equipo.
Gracias. Ahora a los que puedan prender su cámara para que tomemos una foto para dejar constancia de que hemos hecho este evento. Maribel, tú que eres la fotógrafa, si
Sí,
puedes
sí.
hacer la captura, toda la mejor sonrisa.